A Ku Iluna, please rise. Ia ka'aha ho'okolo ki iki hano u a koa ho'omaila. This Honorable Supreme Court is now reconvened. Eloha Ilao, please be seated.
Please call the case.
Case number SCWC-19-0000095. Eckerd Brandies Incorporated, Respondent, Appellant Appellee versus Department of Labor and Industrial Relations, Respondent Appellee, and Scott Foyt, Petitioner, Intervenor, Appellant. Arguing for Petitioner Scott Foyt, Sean Luis. Arguing for the respondent, Eckerd Brandies Incorporated, Richard Rand. Argument on the merits.
All right, good afternoon, aloha everyone. Our argument today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. I'd like to welcome our substitute justice, Judge Matthew Viola. Judge Viola, thank you for joining us. Counsel, are you both ready to proceed today?
Yes.
Right? Yes. All right, we've allocated 30 minutes for each side. Mr. Louise, we're going to give you a warning when there's 10 minutes to go in your 30 minutes because I think you wanted to reserve that for rebuttal. Mr. Rand, we will give you a warning with 5 minutes to go. Please proceed.
Yes. If it may please the court.
Please go ahead. Please proceed.
Thank you, Your Honor. So this case is actually the second time that this matter has been before this honorable court. Originally, the appeal in 2019 was dismissed May 21st for alleged lack of appellate jurisdiction. And that resulted in a writ of certiorari being granted on August 29th, 2019, and on April 20th, the Hawaii Supreme Court, this honorable court, reversed the dismissal and remanded it for the merits, which is why we're here today. And the first thing that I did want to mention, I mean, it is quite surprising that this case is over approximately $60,000 in attorney fees. And this is the second time this has been brought to this honorable court, and I think that says a lot about Eckerd Brandies and its employment practices by not just paying Scott Foyt, who was operating a vacuum truck, his fair wages under the statute. Under Chapter 104, he was supposed to be paid prevailing wages because he was driving a tractor that would basically go to these different construction projects where they're doing rehabilitation and excavation of the sewage pipes. And in order to do this rehabilitation and renovation, they would have to, dig up the pipes and access them. And there would be some cleaning that would be done, which is an integral part of the process. And Eckerd Brandies relied on a letter from 2004 and 2005 that was from then director of the Department of Labor and Industrial Relations as authority to pay less than prevailing wages. And the question that was before the circuit court, whether or not that reliance was reasonable or not. And I would argue that reliance was not reasonable because it was a different administration that was at issue in 2013 when these amounts were assessed against Eckerd Brandies. And even—
Can I ask you about that letter, that July 2005 letter? On the second paragraph, it talks about inspection and cleaning. is not considered construction work, but it didn't connect it with the repair process, did it?
No, Your Honor. It was silent on whether or not, and later in the letter, it talks about whether it would be part of an integral part of
Right, in the
a-
third paragraph, when it refers to repair work, it says work of that nature, though, will be classified as laborer one.
Yes.
Was there any ambiguity between the second and the third paragraphs?
Well, I think the ambiguity was created in practice that actually Eckerd Brandes relied on, claiming that it wasn't, it was misconstruing the letter and taking the whole context of the letter out of context. They
Okay,
should have,
but did the letter say in any part that cleaning and inspection connected to the overall repair work would not be considered construction work?
no, Your Honor. It was included later in the letter that it said that if it's still part of a construction project, something to that effect.
It says work of that nature in the third paragraph, but it referenced the repair type work would still be considered laborer one.
Yes,
And those are two separate paragraphs.
yes, Your Honor.
Thank you.
Thank you. And I think that was pretty clear that because this was constructed, this was attached to multi-million-dollar contracts.
Can you go back to the letter? So is it your position that Director Befetel was without authority to issue this letter, or the letter is so out of tune with the statute that it's ultra vires? I'm trying to understand sort of what the basis it is for you saying that it's not a reasonable reliance.
Yes. So I would say both those things apply. So first, it was not consistent with both the 104 prevailing wage statute, Hawaii revised statute. It was also not consistent with the definition found in Hawaii Administrative Rule 12-22-1, where it talked about construction in the definition section. Construction of public work includes, without limitation, new construction, reconstruction, development, improvement, alteration, repair, renovation, painting, decorating, dredging, shoring, simultaneous sewer inspection and repair, and any other activity performed by a laborer or
You
mechanic.
know, we're familiar with the statute. I guess the question is, why is this letter of July 2005 inconsistent with the administrative rule or the HRS 104? What's inconsistent? Because paragraph 2 is talking about cleaning and inspection only. And the third paragraph is talking about cleaning inspection as it relates to repair work. What's the inconsistency?
So I would say it was inconsistent as it was applied to the facts of this case. It should have been the third paragraph that was applied to the facts of this case, not the second.
Okay, was there anything internally inconsistent with the letter itself? Between paragraph 2 and paragraph 3?
No, because they were separate activities.
I mean, cleaning and inspection alone, were they ever considered covered? I think that's what the first question Justice Evans was posing, and what he's getting at to here is I'm wondering if this letter, maybe you can help me out, really says anything.
Yeah,
It's just saying, hey, look, Eckerd, cleaning and inspection doesn't count. Doesn't say anything about repairs.
yes. So I would say that's where my argument comes in, that there was not reasonable reliance to rely on this letter, because I would argue that Eckerd Brandes misled when it argued that this was, Scott Foyt was doing merely cleaning and inspection, because his job that he was doing with this vacuum truck was classified under basically a dump truck category with a certain amount of cubic feet. I think it was 8 cubic feet or 2,000 gallons of waste. And
Well, I
he-
mean, they're not misrepresenting anything at this point. I mean, the director is just sending them a letter, letting them know what they're doing with the classification of the sewer line, dump truck, and hey, look, inspection and cleaning's not covered. We're not talking about repairs. So I'm just wondering if, your arguments even, yeah, go ahead.
Oh, no. Is it your position that if inspection and cleaning work was done in connection with a broader government works contract to rehabilitate or refurbish a sewer line, that it would be covered?
yes, Your Honor.
Okay, so this letter on its face appears to say the inspection and cleaning function is not considered construction work as covered under Chapter 104. So it seems, the letter on its face seems to exclude that work, whether or not it's part of a larger project to repair and rehabilitate the pipes or refurbish the pipes.
I don't have the letter in front of me, Your Honor, but from my recollection, later in the letter, it said that it was not to be considered exempted from the 104 if it was still part of the construction project. And I don't think it was reasonable that Eckerd Brandes claimed that Scott Foyt was just doing inspection and cleaning, because he wasn't. When you look at the contracts that were listed in the administrative record, it shows that these are rehabilitation contracts for the sewer pipes like in Nimitz Highway and Ala Moana, and those pipes are not found on the surface. They have to be excavated to get to and do the work. So that's why what my client was doing was not just inspecting.
Well, I looked at the testimony, and I believe there was testimony, was it Mr. Higbee? He was a representative of Eckerd. And he testified that the cleaning and the TV inspection, it was done so that we know how we're gonna approach the repair. So it was in conjunction with or part and parcel of the repair work. Foyt also testifies that most of the projects we did involve repairing the lines, and that was the reason we were there doing the TV and cleaning. And then he says, our part of the repair was to verify and clean the pipe to the point where the engineers would accept the type, I think it was pipe, before the repair crew installed it. So it sounds like the cleaning and inspection was like the prep work going along with this process we're calling repair work. Is that your understanding, or is it something else?
Yes, Your Honor, because it was in the record that that Scott Foyt testified at the hearing before the hearings officer that the pipes would have to be cleaned and inspected before they would be repaired.
Right, and then the Eckerd representative, Mr. Higbee, also testified to the same thing, right? He says this cleaning and camera, that was to see where the repair is going to be made.
Yes, and I actually noted that in my writ in the 12 pages that his testimony actually supported my client's claim.
Right, so we're not talking about cleaning and inspection as a service, that alone. We're talking about cleaning, inspection as part of this, the steps or the stages of the overall repair work. Is that what your argument is?
Yes, Your Honor.
And the evidence came from both Mr. Foyt and the employer's representative. Was there any evidence to the contrary?
There was no evidence to the contrary, and in fact, there was a witness from Hawaiian Dredging that presented testimony along with 2 other witnesses that gave testimony at the hearing as to why Scott Foyt, with the possession of his CDL license, was supposed to be categorized as a labor 1 or 2, because you needed a CDL license to operate the vacuum truck. And he said that under the operating agreement in the collective bargaining that Hawaiian Dredging and their engineers work under, that that the truck that Scott Voigt was operating would have been considered a dump truck, which is the same thing. It's a dump truck hauls solid waste away from the work site, and the vacuum truck that my client was operating removes sludge and liquid material and debris.
Were these findings that were made by the hearings officer relating to the repair work involving cleaning and inspection that kind of went hand in hand with this overall repair process, was that found to be clearly erroneous by the circuit court? Any of those findings?
Yeah, well, actually, the circuit court heavily relied on the 2004 and 2005.
I'm talking about the findings relating to whether or not this work constitutes part of the repair work. Were those findings found to be clearly erroneous? by the circuit court?
I don't remember that being found clearly erroneous by the circuit court. I just remember,
I didn't see it either,
yes, Your Honor, thank
but
you.
thank you.
I just remember the court relying
The court
heavily.
relied on the letter.
Ye-
The court looked at the letter and said it would agree with Mr. Foyt's position if instead of saying the inspection and cleaning function is not considered construction work as covered under Chapter 104, it went on to say unless it's integral to a construction contract. So in the circuit court's view, that language being omitted was a blanket determination that it wasn't covered, and the employer could rely on that. What's your response? I know you've been working on this. I mean, I'm trying to understand, is it that the employer, the director simply couldn't have issued this letter, or the letter is so patently absurd that the employer was supposed to intuit that the letter was ultra virus? I'm trying to figure that out.
Well, I'd say that it's not reasonable reliance to rely on a letter from a previous administration 5 years later.
So you'd be okay up until the time that Governor Abercrombie came in? I realize Mr. Foyt was working later than that, but you'd say the reliance was okay up until 2010?
Well, I'm still not okay with the letter being used for its purpose because I don't think the letter applies because Scott Foyt was not doing just cleaning and inspecting. This was not a service contract. This was tied to a construction contract with about 10 projects with the rehabilitation of the sewage pipes.
But the actual work he was doing was flushing out the pipes and running the cable television, right?
In order to do the repairs, the rehabilitation, and the renovation. So it was an integral part of the operation. In the testimony that was uncontradicted before the hearing officer was that it was through Scott Foyt's testimony that I recall that he was explaining that it's a necessary step. You can't just go in and repair the pipes. You first have to inspect and clean and see, because of course you have to go in and inspect, clean, and see what the damage is, and you have to remove the sludge and the material to see the extent of the damage, because he also talked about sometimes how the pipes, they might be replaced or they might actually have another sleeve that's put. There was a thing to that effect, that there's a sleeve put within to maintain the integrity of the sewage pipe.
Would you agree that, I'm sorry.
No,
ahead.
go.
Would you agree that if it's just inspection and cleaning only, just service, that would not be considered construction work?
Yes, if it was part of a service contract for just cleaning and inspection, but these contracts were not service contracts. They were actually rehabilitation construction contracts to rehabilitate sewage pipes.
Come back to my question. Your position is the letter is so absurd on the face the employer shouldn't have relied on it, or he didn't have the authority, Dept didn't have the authority to write this letter, so it was ultra virus, or something else? I'm just trying to understand, like, how would you put it so that we know how it's going to apply in another case where there might have been another determination by the director made, or in another agency where a determination is made? Because this determination is squarely within the authority of the director to make, right? What the wages are for a particular position, whether it's covered by 104 or not.
Well, the director cannot contradict with a letter the statute or the administrative regulation, because then that wouldn't be a reasonable interpretation of the statute in the letter.
But don't they do a survey every year and then write the employer and tell them this is how we're categorizing your various jobs? And in fact, that's what this was. They're saying, okay, we don't have the position anymore of tele-repair, sewer line tele-repair, which by the way wasn't in the feds either. So this is how we're going to handle this situation. How is that not within the scope of the director's ability to or power to opine on?
Well, the director said that that it's already covered, that job classification is already covered under the laborer 1 and 2. So that's why the director was pointing out you don't need that teleworker with the camera classification, because you instead have the laborer 1 and 2 that applies. But I'm not saying that it's not so much that the director, it's that Eckerd Brandes it's them that are claiming that Scott Foyt was only doing cleaning and inspection, but that's misleading because it's cleaning and inspection part of this rehabilitation and correction of the
Okay, but
course.
where in this 2005 letter does it contradict the laws that existed at that time? I'm still wondering, where's the contradiction? I mean, why couldn't the director issue this letter? He's the director of labor.
Yes. Well, I would say that when you look at the definition, no, the letter didn't contradict. The letter was just taken out of context. It was used to,
Okay, that's a different argument. Taking
Yes.
something out of context versus the letter itself in substance contradicting existing law.
yes. No, the letter's taken out of context because Eckerd Brandes is claiming this is a,
Okay, taken out of context by the employer is your argument.
yes, that's, and I'm sorry that wasn't clear with some of the questions.
It wasn't clear because you're arguing ultra-virus, and I'm wondering
Yes,
where is that in the letter?
yes. No, I'm sorry that wasn't clear. It's actually that it's taken out of context because this is not a cleaning and service contract. This is tied to the construction contract. So Eckerd Brandes took the letter out of context and misclassified Scott Foyt and claimed that misclassification was proper to pay him less than prevailing wages.
And that's what the 2013 letter, maybe not clarified, but explained that our position had not changed, that if it's just a pure service cleaning inspection, that is still outside of construction.
Yes,
But if it's cleaning inspection as part of the repair process, that would be part or considered construction. Is that the read on that letter?
yes, and she also, it's interesting, Pamela Martin, who wrote that 2013 letter, also, she was CC'd in one of those earlier letters from, it was either 2004 or 5. She was actually in one of the briefs in the court below. I had mentioned that she was actually CC'd in that letter because she was with the Department of Labor Industrial Relations at that time, according to the record.
Okay,
So she
you-
was aware
sorry.
of, I'm sorry, Your Honor. She was
No, no.
aware of Director Bethatel's letter, and she wrote this in 2013. And that was her position that if the cleaning and inspection is part of a broader construction contract, then that is covered. So I think her letter was very clear.
Right,
And
so you're not arguing that Director Beefentel's letter of July 2005 exceeded his authority. You're not arguing that, are you?
No, I'm not writing because he would be the director.
May I ask a question?
Yeah, oh, please.
So is it your argument then that Director Bethatel's position about whether a cleaning inspection was not subject to the prevailing wage, that was incorrect, legally incorrect?
Well, he was only talking about cleaning and inspection alone. He wasn't talking about cleaning and inspection along with the construction project. And that was the whole point of the testimony by the state's witnesses, was trying to establish through, it was actually uncontradicted testimony that this was part of a construction project. So that's why the 104 in the administrative reg applied.
But the letter refers to work, so the letter says, I'm sorry, I got another letter here. It talks about the work of cleaning and repairing, so it's not focused on the bigger project, it's focused on the nature of the work being done. And there was another letter in 2006 over to Maui. It said the scope of work described for the project, and this is Maui wastewater collection system, which was cleaning of sewer lines, closed circuit television, bypassing of wastewater reporting document and other incidentals, does not warrant any determination under Chapter 104 because the work is not considered as construction work. So, right or wrong, the director's position is it's just not construction work. Whether it's part of a bigger project or not is what I think the fair inference is. But what's your response to that?
My response to that would be that the statute in the regulation does say that if within the Hawaii administration, the 1222-1, if it's part of a construction work and it's integral to the process, that is covered by the 104.
What about the fact that in the reg, it has a reference to simultaneous sewer inspection and repair before it gets to the catch-all provision at the end that you've been citing? Is that, do you think that is, and I think the employer is going to argue that's sort of it in terms of sewer inspection and repair. It has to be simultaneous or otherwise it's not covered. And in this case, the work, as I understand it, that he did was not, he wasn't involved in the repair work, or the repair work wasn't being done simultaneously. I thought that was his testimony. So would you agree that we don't even get to the catch-all or not? And I don't mean to catch you cold. If you can mull it while we hear from Mr. Rand and come back and rebuttal if you want.
Yes, because I did see an or between that, and there was another word before that in the reg. I'll find that exact phrase, but it was an or in between that made it clear. It didn't have to be simultaneous exactly at that moment.
Okay, anything?
Along those lines, is the work ever completely simultaneous? It's my understanding that after the flushing, it would at least have to dry out before the actual repair work was done.
So I don't think, I didn't see that in the record, but.
Okay.
Can I ask one more question?
Yeah, of course.
Yeah. In that letter to Maui, it in the second paragraph, it talks about, from the director, to the Maui representatives, it talked about the scope of the work, and it talked about cleaning and using the TV, reporting, bypassing, wastewater reporting document, other incidentals, but it didn't mention repair work. And it said it considered that as not being construction work. Did I read that letter correctly?
I don't remember seeing that, Your Honor. I think the letter was, and that would be inconsistent with the statute, because the statute says if it's an integral part.
No, it didn't mention repair work. It just mentioned cleaning and all these other things, but not in conjunction with repair. And it says it's not considering that as construction work.
Yes, only if it was cleaning and inspection with nothing else.
What wasn't connected with repair work is how I read the letter. It said the scope of the project involved cleaning and so on, but it wasn't connected with repairs.
Yes, Your Honor, and that's why I don't think.
That's the Maui letter I'm talking about.
Yes, the 2006, and that's actually the one that Pamela Martin was CC'd. But I think that's why.
No, she wasn't. It was
Oh,
Russell
no.
Horikawa.
It was Russell.
Yeah, Ms. Martin was CC'd on the first letter of July of 2005.
Oh, thank you, Your Honor. But yeah, but.
You know what letter I'm talking about? Right?
Yes.
Yeah, okay, thank you.
Anything
very
further
much.
at this point? Oh, Judge Viola? No. Okay.
No.
Anything further, or do you want to just reserve your time for rebuttal?
I'd like to reserve my
Okay,
time.
very well.
Thank you.
We'll hear from Mr. Rand at this point.
Thank you. Chief Justice Reckenwald, members of the court. Actually, what happened below, I guess I'm the only one in this room who was there, so I'm very knowledgeable what happened below. Let me start out with how limited this case actually is. The circuit court got it right, and the circuit court only decided one thing, and that is that the Department of Labor could not retroactively change its mind in 2013 for work that had already been bid and almost all done prior to that change. And let me also point out that Mr. Foyt's employment ended before the 2013 letter. So all of his work was done before the 2013 letter. All the circuit court decided is Department of Labor Industrial Relations, you issued a ruling in 2005. This letter, which I'm sure everyone has read many times, which we submit is unambiguous and clear. And it divided the work really into three buckets: cleaning, inspection, and repair. And Director Beffatel said, if you're doing repair work, it's still covered under 104. And to the extent that Mr. Foyt did repair work, he was paid as a laborer under 104. Now, the cleaning and inspection functions, Director Beffatel made it very clear that is not construction work. And my client relied upon that in bidding all of the contracts at issue in this case. And then Mr. Foyt filed his complaint after he was terminated. We get the 2013 letter, and the Department of Labor tries to change its mind. And the circuit court was right. You can't do that. Okay, you just can't do that under 9114, and I
Can't
would
do that prospectively or retroactively?
retroactively, Your Honor, Justice. Yeah, you can't do it. The circuit court was very careful. He said, I'm not deciding whether Pamela Martin's letter was right or wrong. I'm not deciding whether she has the authority to change her mind. I'm not deciding what her letter means. I'm only deciding one thing, and that is Eckerd Brandish was entitled to rely on the 2005 letter. It was within the director's authority. They relied upon it. They bid these jobs. They worked these jobs. And the subsequent letter, you cannot go
Along
back.
those lines,
Yes.
I did have a question as to the practical effect of any potential retroactivity of the 2013 determination. You are here actually fighting, is it just the fine or is it the wages due?
The wages too. And so what happens is, there's a notice of violation.
Right,
You get assessed, and you have to pay that to appeal.
right.
And so my client paid it. We had the administrative hearing before the hearings officer where he upheld a notice of violation, which was issued based on these contracts and the classification of truck driver, which had never, ever come up
Okay,
before.
so here's my practical
Yeah.
question. If there's a determination that the 2013 letter was correct and has retroactive effect, does it affect your company and or any other companies as to other employees and any potential wages due?
It affects my client for anything they did where they did not pay people who were doing only inspection and cleaning. He does have a competitor who's mentioned in the Maui letter, but I believe he only does inspection and cleaning, but he does it, we do inspection and cleaning and some repairs. The other company does inspection and cleaning, but they also do it on the same type of jobs we do. So it would also impact them. There's another negative effect of it.
I'm just wondering, does the record reflect any calculation of what this would mean in terms of financially?
Only with respect to Mr. Foyt, because he's the only one to complain.
Right, okay.
The
But there
department-
are other people that this would also apply to,
Yes.
and other jobs.
And other jobs. And let me also point out, Justice McKenna, that, the under 104, there's an escalating series of penalties.
Right.
And when you get to your third one,
Is this considered the first penalty?
Yes, this was the first, although at the hearing, the Department of Labor admitted they thought about treating each project separately, which would have meant my client would have been debarred, prevented from doing government work because they relied on the 2005 letter.
Okay, but as a practical matter, so if the department's the administrative decision is upheld here, that means that you would have to go back and pay different employees additional amounts? Is that what it means?
It's possible. I don't know what the Department of Labor and Industrial Relations would do. We would have to pay Mr. Foyt, I think it was $60,000, because it's not only unpaid wages, but it's a penalty. And it would also mean, again, we get strike one. This would be our first strike. And if within a certain amount of time, you get two more, even if they're small, this is the Paul's Electrical case, you're out. You can't do government work. So
Mr. Rand, what's your take on the hearings officer made a finding that the testimony of Mr. Lum was given credence to the effect that the department had always believed that this kind of work would be covered? Are you familiar with that?
Yes, I'm very familiar with that.
Okay.
And
is that something we're bound by unless we find it's clearly erroneous? Or
no, it was not. If you look at the decision in order, there's a number of findings of fact at the beginning. And there's nothing about Mr. Lum in the beginning. And what happened was the hearing officer admitted that this whole approach, this is, and to me, it's overuse of the word integral. Integral became a catch-all for the Department of Labor. Oh, if it's integral, it's covered. Now, the regulation, which I'm sure the court has read many times, actually doesn't use integral in that sense. It talks about other work, and then it says the following is covered if it's integral, and it lists 6 things, none of which apply in this case. So Mr. Lum's testimony was was quite interesting because at first he and the investigator said, "What letter? We don't know about any 2005 letter." And the hearing officer, if you look at our brief where we quoted her, I said, "Did you consider this letter?" And she said, "No, I didn't even think about the 2005 letter." What the hearing officer also noted in his decision and order that this whole approach came from, this is on page 18 of his order, the state's investigator met with Wesley Lum and Pamela Martin. They determined as long as the work was integral to the project, it's covered. So instead of having a regulation under Chapter 91 or a statute, what we had is 3 employees in the Department of Labor getting together in a hallway and deciding how to analyze this case. So I think the hearing officer's reliance on Mr. Lum was it was erroneous. It was wrong as a matter of law. Mr. Lum has no authority to interpret this statute. Okay, he's just an employee of the Department of Labor. He had no authority to contradict the 2005 letter, which he ignored. They've taken many approaches to that letter. The first was it didn't exist. The second was, oh, it has an exception if the work is integral. And I asked all of them at the hearing, where is that word in this letter? Find it for me. Oh, it doesn't appear there. This letter is very clear, and I think the court's already identified why this letter, why we were entitled to rely on it. It says the inspection and cleaning function is not considered construction work. I don't know how much clearer the department could be. And under the regulation, which is 12, the statute itself doesn't really address this, but 12, the statute does, the regulation. And I believe, I forget who, I'm sorry to point that out, I think it was you, Chief Justice, simultaneous inspection and repair. So the statute had already addressed this. And what was significant in the hearing was when I asked everybody, all the Department of Labor employees, did you ever determine whether it was simultaneous? No, they don't care about their own regulation. So you have a regulation that covers a certain part of this work, simultaneous inspection and repair. And if I can go back.
What does simultaneous mean under these?
To me, at the same time, and I want to go back to a question you asked Justice McKenna.
I'm sorry, go ahead.
About that. So we learned a lot about cleaning and repairing sewer pipes in this case. So what happens is you first shoot the water. What Mr. Foyt did is essentially a huge pressure washer. You shoot the water through. And then they inspect, and the inspection is used to determine whether any repairs are needed. If we're going to do the repair, we're actually doing it at the same time because we're making sure what they do is they sleeve the pipe, essentially. They described it as putting a tube sock in there and blowing it up. But you have the camera there to make sure it's working, so it is simultaneous. But Mr. Foyt testified that when he did his cleaning, because that's all he did, they would come back later that day, the next day, months later. It was never simultaneous. We couldn't be there at the same time as the general. Two people cannot be.
He didn't do the inspection also?
He did not do the inspection. He was the guy that drove this truck. He basically drove it to the site. They hook up the hoses, they push the water through, they vacuum it out, and that's it. Then after that, the inspection is done.
Okay, but the way Mr. Higbee, your own representative described it, he was describing a repair as a process where you have the cleaning inspection and then the sleeve or whatever, patchwork is done. And then you have another follow-up inspection to make sure that the repair is tight. But he described it as a process. I think he talked about angioplasty as that kind of process where you have a camera being used and so on. But it's all seemed to be part of under the umbrella of repair work. At least that's how I read his testimony.
Yeah, so he was, I think, testifying as to when we do it, the cured in place. So he was talking about the procedure when we do the repair work, and he never disputed that was 104 work, and he would pay everybody 104 wages. In fact, he said that he would pay anybody on the job that day the 104 wages, no matter how much time they spent on the repair, because it was just administratively easier. So what he was describing is when they're going in and they're doing a very small repair. But Mr. Foyt testified that they would never do it at the same time. And this is the record on appeal docket 18 at page 145, where he said It sounds like the cleaning would come first, and the people would come back later. And he said, correct. And then he went on to say, and this is at page 148, or excuse me, 149, he would say, normally them type of videos was produced throughout the job, but we waited until we had several liners in place. So it didn't happen right away after they installed it. It could be a week, it could be a month. And he testified that they were never there at the same time as the general contractor doing the repairs. They just physically couldn't be there at the same time. But we have a regulation that people seem to ignore that talks about simultaneous inspection and repair. It never talked about cleaning. And we would submit that the reason it's written that way is to be consistent with the federal approach, because the federal approach is reflected in their the Wage and Hour Field Operations Manual, which talks about we cover simultaneous work. We don't cover inspection only. So the director, you know, they got it right, and the circuit court got it right.
Mr. Ryan,
yes.
may I ask a question?
Absolutely.
Is there anything in the record that indicates how your client compensated the cleaning and inspection work prior to 2005? Did they make those distinctions between simultaneous work or connected to a repair job, or did they just pay everybody the prevailing wage?
Actually, they paid the prevailing wage. So that's why they had the sewer line tele repair classification.
Is there anything that indicates why they paid that prevailing wage to everybody?
That was the classification. They applied it to everybody. I think it was just, it might have been administratively easier, and I think they just felt, okay, that's the classification. It covers all of our employees, and we'll pay it. Now, you're right. They could have limited it, but they didn't. And then, you know, again, the director who has the authority, and I'm glad Mr. Ruiz conceded he has that authority. He said, I'm taking away this classification because this work is not construction work. And everyone agrees if you take inspection and or cleaning separately, they're not construction work. They're not inherently construction work.
But wasn't it also because the federal government does not have that classification?
I think that's part of it. And I think, again, Justice McKenna, I think our regulation was written with an eye on the federal field operations manual, that the simultaneous is covered, but standing alone, they only talk about inspection in theirs, standing alone cleaning is not. So I think he wanted to be consistent with federal law. He was also concerned at that time that the tele-repair classification was now below the federal laborer classification, so we need to bring it up and use laborer.
Does this mean that based on the 2005 letter, people that were doing the work like Mr. Foyt, their pay went down?
I don't know that it went down. I think they had the ability to pay them the shop rate when they weren't, you know, doing repair. So I don't know if we had testimony in the record that their pay actually went down because his shop rate might have.
So how much more was this 2013 rate?
Well,
I saw something about, I was very confused as to what the difference was.
Yeah, it is confusing because after 2013, the testimony from my client was he paid everybody laborer 1 or laborer 2, period. Okay? And the Department of Labor didn't seem to have an issue with that. The problem was the calculations are based on truck driver, which was not ever really part of this classification. And what the department told us is it's laborer. And the truck driver came out of, frankly, left field. So that was the $56,000 they calculated. So going forward after 2013, everybody got laborer 1 or laborer 2. I don't know that it was actually an increase in their pay, but they actually paid everybody laborer 1 or laborer 2 who was on the job no matter what they did.
Why would Foyt be getting a higher level of pay? I mean, it must necessarily be he was being paid at a lower rate.
Well, Foyt should, that was the problem here because, you know, the prevailing rate is supposed to be on similar projects of a like nature in the state. That's in the law, that's in the regulations. So instead of doing that, what happened here is the investigator called the operating engineers. Why? I don't know. And I asked the representative of the operating engineers who testified. By the way, no one from Hawaiian Dredging testified. This is at Record on Appeal docket 18 at pages 117 to 118. And I asked them, do you know which companies under the master agreement do CCTV, sewer inspection, and cleaning? No, I don't. Can you think of any? As you sit here, no. And I asked him, in the repair of sewer pipes, that's not an engineer function? And he said, I don't have experience with that. So Foyt got an artificially high rate because the inspector did not do her job to determine what's the practice among the people that do this work. That's how prevailing wages work. You look at the people that do the work, similar like projects, and that's your prevailing rate. So I don't have a good explanation for that because it was shocking to me that they went down that road. But
Can I go back and ask you about the simultaneous timing of the cleaning, inspection, and the actual changing of the sleeve?
Right.
Because when I looked at the testimony from Mr. Higbee, he was asked, is it most of the time that when you do these repairs that you have to do the cleaning inspection first? And he says, yes. And then he was asked, is that because you have to clean it out, otherwise the sleeve won't adhere to the sides? And he says, yeah. So it sounded like prep work done hand in hand with the overall repair process. Is that a correct understanding? So it doesn't sound like simultaneous exact time you're doing all these things at once.
when we're doing the repair, it is very much close in time because we're going in there to make sure the repair works.
That's not what he said in the testimony.
I think if you look at his testimony, he was asked about when he does it. Because when we...
No,
when
he was
some-
asking about, he was just asked in general. And he said most of the times he agreed that you have to do that prep work first.
Yeah, I would agree with that. You do that. The only
So
reason
it's
we're...
not simultaneous.
Right, we're not, it's not simultaneous, and we're on the job to determine, you know, we clean, obviously, you can understand why they clean. They go in and inspect, and then that video goes to the engineers in most cases. If we're doing it, it's probably right there. If we're not doing it, it goes to the engineers who are in charge of the job, and they decide how much the repair needs to be done. No repair is done, no repair is done. If the pipe is beyond repair, only then do they have to install a new pipe.
Who testified to that?
I think he did, and Mr. Foyt did. I mean, I haven't read all of the testimony again, but
Mr. Foyt seemed to testify that the repair process, his part of the repair process, as he explained it, was the cleaning and the running the TV. But he considered that part of the repair work, overall repair work.
well, of course, yes, he said that, but the repair work, it's a separate function, okay? They don't go on at the same time unless we're putting a little liner in place and we're doing the inspection.
Didn't you earlier say that Mr. Foyt only did the flushing?
Yeah, he only did the flushing. So
But-
if he did,
But he also did the TV, CCTV
I
too?
think he testified that on occasion when he had nothing else to do, he would assist with it, but that was not his primary function. And the Department of Labor classified all of his hours as truck driver. So they never made a distinction if he was doing the CCTV work. They just paid him all the hours as truck driver. They never made that distinction. But his
I'm getting confused now. Are you saying that, all right. So before 2013, what was his classification?
Cleaner.
Cleaner. And now you're saying that after the 2013 letter, your client is now paying everyone that did work similar to Mr. Foyt as a laborer 1 or laborer 2.
Correct.
But you're saying that the department said that he gets paid as a truck driver.
That's what happened in this case. They said he needs to be paid as an operating engineer's truck driver without doing the analysis required under the regulations, which is you look at the practice among workers.
Would it have made a difference whether he was paid as a laborer 1 or 2 as compared to a cleaner? He would have been paid more?
I think laborer 1 and 2, the difference was, and I believe Mr. Higbee testified to this, is once they took away that classification, some employees were paid what they called the shop rate. Now, we never had evidence in the record of what that rate was, because the hearings officer found that Mr. Foyt was always paid as laborer 1 or 2, which I don't quite know how he got there.
So he wasn't actually paid as a laborer 1 or 2?
That's what the finding was. To me, that's not quite consistent with the testimony, but that's what the
Did you
DLF
challenge that finding as clearly erroneous?
I did not.
You didn't appeal?
I didn't appeal.
All right, so.
Well, I did appeal I did appeal the hearing officer's decision.
Right,
But
okay,
I appealed it on really a different basis.
okay. Okay, thank you.
But, you know, the Mr. Lum's testimony, which the hearing officer relied upon, we would submit to this court that it's inconsistent with 1221-1 because the use of the word integral is in relation to other work performed. And then you look at the functions and you determine whether they are integral. Now, there was also testimony about the FAQs that Mr. Lum was so proud of and relied upon. And they, of course, are not Chapter 91 issued. But the interesting thing about the FAQs, and this is Record on Appeal, docket 16, page 314, it has two columns. The left column is construction work. And what do they say? Sewer inspection and repair. It's right there in their little FAQs. That's
But
an
it also has repair as a standalone classification, or at least a construction description as well, correct?
I'm sorry, Your Honor?
It has repair as a separate,
Yes, just a
consideration
general
is-
repair. But there is a very specific reference to sewer inspection and repair. They leave out the word simultaneous, though, so it's not quite consistent with the regulation. So,
But isn't that statute, or I'm sorry, the administrative rule, it says without limitation? Isn't that what it starts with?
it does, and it talks about the various functions, but there it says simultaneous sewer inspection and repair.
Right, but without limitation.
Right, without
It
limitation.
also talks about repair work, right? I mean, it doesn't really come down to how we define what the repair is or what the repair work involves.
We would submit to this court that when you have very specific language in a regulation, that controls. It's a general principle that specific language controls over general.
So without limitation would control as well, right?
That is general to me. The specific is simultaneous sewer inspection and repair. That's the language that's controlling.
What
here.
does again, let's get back to the end, what is simultaneous?
Yeah,
To me,
I
it
had the
means
same question.
the
So what
common
does it
sense.
mean in a common sense?
It's at
way?
the same time. And it is possible to do inspection and repair at the same time.
Why would you, that very, very narrow type of work, why would that be addressed specifically in the regulations? Seems like an odd thing to pick on of all the, painting, renovation, repair, dredging, this is all large elements of a job. Why simultaneous?
I think it is to be consistent with the federal government. Because if you look at the field operations manual, and that's the only evidence we have of really the federal practice, they say the same thing, simultaneous inspection and repair.
And so simultaneous, I'm still confused as to what simultaneous would mean then. Would it be simultaneous if it was the same day?
No, to me, simultaneous means at the same time, because it can be done that way. You could have the repair going on and they're watching the repair to make sure it works. That's simultaneous. If you're coming back later in the
I'm
day.
sorry, so you flush it first
Yes,
and then you put in the cable and you're looking and you see, the same instrument does the repair?
no, different instrument.
So you got to pull the cable out?
I think they can have the little TVs can fit in there while you're doing the repair. I never actually did it, so I'm basing it on the
So you
testimony.
can have a different instrument following the cable, the TV? Is that what the testimony is? I
or
don't
in front of
understand
it,
how
yeah.
this is
You
done.
have something that they call it a part liner or a cured in place liner. It's basically you're sleeving it from the inside. And so you're watching that to make sure that it.
You don't have to take the TV out first to do the repair?
Not from what I understood Mr. Higby's testimony to be. You could do it at the same time. They're
Wow,
watching
how
it.
could you do that? Like, you have this TV cable going through, and then you're lining it, but then the TV cable line is still there too, right? I'm sorry, I
Yeah,
don't really understand how this works.
I think the repair is in front of you, and you have the cameras in back of you, so you can watch the repair and make sure it works.
I see.
What an odd thing to focus on. Okay, so
you
you
know-
laid it off on the feds, but like, why are the feds of all focusing on whether it's simultaneous?
You
It
know,
just doesn't like jump out at me that somehow fits with the purpose of the statute, but maybe you don't know, so.
I don't know, and I would agree it's odd, but it is the regulation. And they're bound by the regulation.
So your position is because there's that very specific reference to what is covered, that you don't even get to the catch-all? Is that what you're?
Correct. You don't get to the catch-all. The catch-all is only if it's not already covered. Otherwise, there's no.
I'm sorry. You just said they're bound by the regulation. They're bound in terms of the minimal requirements, right? By the federal requirements. You have to at least meet the federal requirements, right?
You do. I mean,
The state could actually impose additional requirements, right?
Absolutely, but they didn't. 1221, this regulation's been there. It's always been there.
All right.
And the problem is, again, if you look at the testimony from the hearing, did you ever look to see whether it was simultaneous? The answer was no, they didn't care. Okay, and the hearing officer didn't care. So our position in a nutshell is the director got it right. He had that authority. We relied on it. The circuit court got it right. The ICA got it right. And we're going to ask this court to get it right and affirm it.
May I ask one
Yeah.
question? So what if there's a determination that your interpretation was incorrect? Does that mean that any reliance was necessarily unreasonable?
Not necessarily. The only time this court has said you cannot rely on a pronouncement from an agency is where it's ultra vires. And that was the Turner case, I believe, where they didn't have the authority to do it. But I think this court's approach in these cases is, look, if the agency says something and it's within its authority, it's not whether the agency was good or bad or right or wrong. Someone can rely on it, and we did here.
Unless it's unreasonable reliance.
Perhaps. I think that in Turner, it was really, I think it was ultra vires. They gave someone a benefit who was not entitled to the benefit. So, thank you.
Can I ask one last one?
Absolutely.
Was Mr. Foyt involved in excavation? Because if we don't go with your argument, we look at the catch-all, and then if I understand your argument about the catch-all, it's if it's integral and it's one of these 6 categories, and I think I heard Mr. Louise refer to excavation work. Is there excavation work that was being done by Mr. On these projects or by Mr. Foyt?
Absolutely not. And let me also point out that word net does not appear in his briefing to the ICA. That was brought up in his application for certiorari, I suspect, to try to fall within one of those 6. But no, we don't do excavation. We don't have the equipment. We don't do excavation, Mr. Chief Justice.
And are you even licensed to do excavation?
We don't have we have a very, we're basically cleaners and CCTV. Okay, thank you.
Thank you very much. Mr. Luis.
Okay, so I did want to focus on a couple things. So Scott Foyt's testimony was that, and this is in the administrative record, the Record on Appeal Part 3, PDF page 128. Petitioner basically shot water through the sewer pipes to clean the debris out of it and vacuum the debris that came out of the pipe into the debris tank. And then there was also that same PDF Part 3 at pages 135 to 136. Mr. Foyt testified that most of the projects involved repairing the lines, and that was the reason for doing the TV and cleaning. That testimony is not contradicted by anyone in the record. Bigger projects included putting a brand new line or virtually rebuilding the pipe and repairing permanently or putting a permanent liner in it, and that's from Record on Appeal Part 3, PDF 135 to 136. On cross-examination, it was elicited that the cleaning would be followed by repairs and inspection. And that citation's Record on Appeal Part 3, PDF 145. It was also in the testimony that cleaning was an integral part of the repairs and rehabilitation of the sewer pipes, Record on Appeal Part 3, PDF at pages 149 through 150, and Record on Appeal Part 3 at 149 through 150. And that's consistent. The investigator reported that Foyt informed that he was paid for the correct number of hours on the construction project, but he was improperly compensated on these government construction projects as labor 1 or 2, when he should have been compensated as equipment operator, and that's in the investigative report. PDF at 100 in the investigative report. And that again is consistent with the testimony by Miles Miyasato from Operating Engineers that said that Scott Foyt, that the vacuum truck would be compensated as a truck driver, tandem dump truck over 8 cubic yards, water level, water truck over 2,000 gallons, classification as commercial driver's license is required to operate a vehicle of this size on a construction project, and that as a general rule, a laborer or mechanic on a construction site operating such a vehicle required the operator to have a CDL license. And that was the testimony of Brandon Ali at PDF 56 through 61. And I did want to go back to this language in the regulation, because in addition to talking about in the beginning of construction of public work that includes without limitation new construction, reconstruction, development, it does mention simultaneous sewer inspection and repair. But when you get closer to the bottom, it also states, as used in this definition, other activity performed by a laborer or mechanic employed at the site includes the following if the activity is an integral part of or is in conjunction with construction contract, or if there is substantial construction activity involved in a supply, service, or other type of non-construction contract. So it is true that in one section it talks about simultaneous repair, but in other sections it does not. And it makes it so broad that it covers not only construction contracts, but non-construction contracts if substantial construction activity involved in the supply, service, or other type. And this truck was being supplied to remove debris and inspect and clean in conjunction with that work. And the contracts includes, when in the meaning of the regulation, anything
When
over.
you say clean, it's not flushing, it's sucking?
But yeah, it's cleaning by flushing and extracting the debris and going into the truck. And then my client, of course, would have to transport.
And that's in
truck.
the record, that it wasn't just flushing pipes so that the pipe, whatever was going through the system toward wherever the sewer was going, but it was actually
Removing it.
removing.
Correct. He was removing the material too, and that material had to be hauled away. It can't just be left on the work site. And even under the labor 1 and 2, it was also noted that because of the testimony of all the witnesses, that even that classification was incorrect, and he would still be owed about $29,000 even under his classification. So under one classification, the labor 1 and 2, he was still owed $29,000, a little bit plus, because of the activity that he was doing. And then under the other classification that the director, the hearing officer was urging, was about $55,000. So he was paid the wrong wages one way or the other, and that's why we asked this honorable court that it would correct what the circuit court did, because it kind of deprived Mr. Foyt of his opportunity to be paid a prevailing wages under either of those categories, whether it was considered as the engineer with the 55,000 he was owed.
Under the 2005 letter, would he have been, didn't the 2005 letter refer to laborer?
It just refers to someone who's cleaning and inspecting as part of a service contract. So I don't believe the letter even applies, and I think the circuit court erroneously relied on that letter.
All
Thank
right,
you.
thank you very much, Mr. Luis. Mr. Rand, the court will take this matter under advisement.
Yes, thank you very much, Your Honors.
Eku Iluna, please rise. Ua ho'oku'u ia mai ne kea aha, ho'okolokolo ki eke hanohano o ka moko aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.